Hello, everyone, and welcome to another episode of Women Winning Wednesdays. I am your host, attorney Elsa W. Smith, and I'm the owner of the law offices of Elsa W. Smith, where our mission is to empower women through estate planning. We have a good show for you today. We're going to actually be reviewing, or it's the part one of this review of our estate planning checklist. It's a 21-point checklist that we created. It's on our website at elsawsmithlaw.com in the resources section. But I thought it a good idea to just go over points covered in the checklist, as well as answering some common questions that are raised. So as you saw on one of the taglines, please let StreamYard view any questions or comments that you have during the broadcast. And again, I'm so appreciative of you being able to join me. Feel free to share this video. We are streaming on YouTube, LinkedIn, and Facebook. So with that said, the topic, estate planning checklist, part one. So here we go. One of the first things, that you should consider, and this is one that most people are obviously thinking about, are wills. All right, so let's start talking about those. In very simple terms, a will is a legal document that dictates how you want your assets to be distributed after you die, right? You create it. Can it be amended? Absolutely. But it has no effect until you die, but you can change it and amend it, as I said, whenever you want. To be valid, the document, that will, has to comply with several requirements under your particular jurisdiction's laws. In Maryland, for example, a will doesn't need to be notarized, but it does need to be witnessed, and you need to have capacity, meaning that you understand what it is that you're signing, what the property involved in your will, and you need to be able to appreciate what it is that you're doing. That's what we talk about capacity. That's what we're talking about. A will also includes specific instructions on how you want your estate, everything you own, to be distributed. Now, let me pause here for a second, because a lot of people say, well, I don't have an estate. Let me correct you on that. If you have a bank account, if you have a car, if you have any kind of personal property, things that you own, clothes, shoes, collectible items, really, and even digital assets, those are all part of your estate. That's all your stuff. So it needs to be protected. So going back to the will, it includes instructions for how you want your estate to be distributed. And you can also include instructions on tangible personal property, like the ones I mentioned, jewelry, furniture, and so forth, as well as naming guardians for your minor children. So why do you need a will? So let me say this, any type of person, whether you're married, divorced, single, child-free parent, or a parent, whether you're in good health, bad health, particularly if you're in bad health, you should have a will, for the simple reason that without one, you can't determine who is going to receive or who should receive your property. Now, each state has a plan for how property must be distributed if you die without a will. That's called dying intestate. And those of you who follow this program know what that word means, because I have mentioned it many, many times. And we do not want anyone watching this show to die intestate. Now, if you have children, if you have causes that mean something to you and that you want to be a blessing to through your estate, then you definitely, at a minimum, want to have a will. Now, the next item on our checklist is, oops, here we go, is a trust. There we go. Gotta love technology. Now, a living, or also known as an inter vivos, that's a fancy way of saying living, right? During your lifetime. That kind of a trust allows an owner to plan during his or her lifetime, assets, how assets move, how assets can be distributed. Um, the good thing about having a trust is that you bypass the probate process and controlling decisions, and you maintain control of decisions related to the distribution of your assets. Now, a trust not only identifies who can benefit from those trust resources, that trust bucket, if you will, but it also defines how and when those assets are to be distributed, especially, but not exclusively, but especially in cases of your incapacity. Now, anyone concerned about facing a stroke, dementia, Alzheimer's may want to consider using a trust to ensure that their resources are preserved, managed, and spent in line with their wishes while they are under the care of a loved one or a health professional. Now, trusts are extremely flexible in terms of how you can administer them. For example, you can appoint a trustee to help assist beneficiaries who may struggle to manage funds that you leave to them. Now, while we're on this point, I just want to clear up some definitions. Like, what is a revocable trust? Because I have a lot of people calling me, contacting me, wanting a revocable trust. For the benefit of the audience, let me just say, pardon me, a revocable trust is a trust that can be changed at any time and in any way during the owner's lifetime, up including, you know, total revocation. You can dissolve the trust, revoke the trust is a better word to use, thus the name. Now, what's an irrevocable trust? On the flip side, an irrevocable trust is one that cannot be changed or revoked after the agreement has been signed. And a revocable trust becomes irrevocable upon the death of the original trust owner, in this case, you. So just to clear up those definitions. So a trust is certainly, I mention it because many people talk about it. A trust may not be a good fit for you, but it is a good fit for a good number of the people that we serve. So the way you're going to decide one way or another, I would submit, is through the assistance, working with an estate planning professional. Let them examine your total situation and see whether a trust is the right tool for you in your particular circumstance. Now, next, we're going to consider the power of attorney. A power of attorney, what is it? It's a document that gives one or more persons the power to act on your behalf, right, as your agent. Now, the power can be limited to a particular activity, like closing on the sale of a home, for example, or it can be general, a general power of attorney. The power may be given temporarily or permanently, depending on how you craft it. The power can take place immediately, can take effect immediately, or upon the occurrence of a future event, or upon the occurrence of your incapacity, your inability to act due to a mental or a physical disability. Now, an important reason to use a power of attorney is to prepare for situations when you may not be able to act on your own behalf due to absence. You may not be physically present when a transaction needs to be executed, or if you're incapacitated. Now, that disability, that incapacity may be temporary due to travel, an accident, or an illness, or it can be permanent. But in any event, a power of attorney can be helpful in all of those scenarios. If you don't have a power of attorney and you become unable to manage your personal or business affairs, it may become necessary for the court to appoint one or more people to act on your behalf. And you may have heard the term guardians or conservators. That's what we're talking about. These are people that they're acting on your behalf, but they have been appointed by a court to do so, to manage your person, your health and welfare, as well as your property. The next thing you want to consider on the list is a HIPAA authorization. Now, HIPAA refers to Health Insurance Portability and Accountability Act. It's a federal law that gives, where you give written consent for healthcare providers to discuss your healthcare information with others, including your family members. Now, why would you need to share that information? There are many reasons when you need someone else to access your personal medical information. If you're a patient, you'll need to give personal information to a doctor, a hospital, or a healthcare provider. Then those people who handle private records often, like doctors, hospitals, healthcare providers, again, may need to get authorization from their patients to share with an attorney or other party. Here's a scenario. You might grant your attorney access to your healthcare information to prove, your injury wasn't pre-existing if you're pursuing a personal injury claim, right? You may also want to grant permission to your healthcare agent to question your doctor about a bill if you are hospitalized or incapacitated. The next document we want to talk about is an advanced directive or healthcare power of attorney. Always remember that an advanced directive is used if you are in danger of dying and need emergency or special measures to keep you alive, but you are not able to make those decisions on your own. An advanced directive allows you to make wishes about your medical treatment known. Now, writing your choices ahead of time can spare family members from really heartbreaking choices about whether to keep you on life support. Advanced directives can also state what types of treatments you want in different situations. For example, you can tell your doctors how aggressively you want them to treat you and to what extent you want to be kept alive. It can tell people at what point you would prefer a natural death instead of being kept alive by ventilators, feeding tubes, or other mechanical means. Or it can state you want all life-sustaining treatments, even if they were unpleasant to you, or even if there's a chance that you may not fully recover. You can state, basically pull out all the stops, try to keep me alive. Whatever your decision is, it's most importantly to remember it's your decision. There is no right or wrong answer. And each person's choices are dictated by their values, their religions, personal beliefs, and their life experiences. So like I said, there is no right or wrong answer. And guess what? whatever you decide can change. What you think you want to happen with your life, and that's in those situations at like 20 or 30 can be significantly different than if you are, 95 or, reaching 100. Um, so just something to think about. Um, so beneficiary forms, that's the next thing we're going to talk about. Reviewing your beneficiary designations is a critical part in your overall estate planning process. It ensures that if you're talking about life insurance and other retirement plan proceeds are given to people or organizations that you want them to go to after you die. It only takes a few minutes to make sure your designations match your current wishes. Now, what are the dangers of out of date beneficiary designations? Let me tell you, beneficiary forms trump last will and testaments in court. So those assets, with assets to, let me rephrase that. So those with assets to pass on to their heirs should regularly update them. The nightmare scenario that I've mentioned quite often is the case where, husband leaves or husband has $1 million life insurance policy and names his first wife as the 100% beneficiary. He divorces, remarries, does not update that life insurance policy. When he dies, guess who gets the $1 million? Wife number one. Wife number two is left holding nothing. She's dust, lint. She's got nothing. And there's nothing she can do about it because that beneficiary designation, it's a contractual agreement between you, the deceased now, and the life insurance company. And they are simply following what you instructed them to do. So it's a horrible situation, not one that people want to do, have happen to their surviving spouse. But it does happen, and it happens quite often because people forget, life gets in the way, and that is one thing that I remind my clients to do. I mean, over and over and over again, is review those beneficiary designations. So, the other danger of having out of date beneficiary designations is, when administrators, not plan administrators, but like when a system changes, maybe a computer system changes that the insurance company or bank uses, that could have an unintended effect for some strange reason. I'm not a techie, but things do happen. So that yet is another reason to check your beneficiary list regularly. Even if you think that nothing needs to change, just every couple of years or so, just lay eyes on those designations. And like anything, naming a beneficiary can come with an unexpected cost if you name an irresponsible minor, or just a minor, period. You should not be naming minors as beneficiaries to life insurance or other policies, because they are not legally able, they don't have the capacity under the law to receive, to take ownership of such an asset until they become an adult. And what that age is will depend on your particular state. So the next thing you should look at is your children's inheritance. So a question I get is, how do I leave money to a minor child? I just said that you should not you should not name a minor child as a beneficiary to a life insurance policy. Now, minors can't, as I said, can't own assets in their own name until they become legal adults. What that is will depend on your jurisdiction, as I said. Naming a minor as a beneficiary without also naming a custodian could cause delays in receiving those assets if you were to pass away, right? In your will, you can name a guardian for your minor children. You can also name a property guardian. The legal guardian would be responsible for managing your child's care, while the property guardian, would oversee any assets that you left to them. Now, this can be two different people, or it can be the same person. You could then list out the assets that you want your child to receive. If you have multiple children, you can specify what percentage of assets they should receive instead, just to keep things simple. Let's say if you have 4 kids and you say you want them to receive, your estate, 25% each, and like equal shares, that makes it relatively more simple to administer your assets. So aside from a will, you could also establish a trust, which we talked about earlier. A trust can hold those assets inherited by minor children. You could name a trustee who would oversee those assets according to your wishes on behalf of the children listed as beneficiaries. Now, establishing a trust allows you to leave specific instructions for the child's inheritance. For example, you could state that your child won't receive the bulk of their inheritance until they, for instance, graduate college or reach a certain age, whether it's 25, 30, 35. Another question I get is, should people leave different amounts to their kids? The standard advice among experts is to divide your estate equally between your children. But there are many reasons why parents may choose, another option. There was a Merrill Lynch Bank of America study in which nearly 1 in 4 of the people that they surveyed said that a child who has children of his or her own deserves more money than a child who doesn't have kids. Something to think about. And 2/3 said that a child who steps in as a primary caregiver for an aging mom or dad deserves to inherit more than the other siblings. And 40% of those participants, the participants in that study with blended families, okay, think Brady Bunch, okay? And I know I'm dating myself with Brady Bunch, but just work with me. Those participants with blended families don't believe that they should treat stepchildren the same as biological or adopted children. Okay, so very, very different opinions. Again, there is no right or wrong answer, but you have to be the one to decide, right? Can one put the legal guardian and the children's name together? And the children. Not exactly sure of the question. Let's see. Can one put the legal guardian and the children's name together? The legal guardian is named, hopefully, Elizabeth, hopefully this answer helps. The legal guardian is named in the will. And if you want the legal guardian to be for a particular child, I'm not sure if that's what you mean, then yes, you can absolutely state that in the will. Great question. Great question. Let's see. What else here? Great. I love that if people are engaged. The next thing you want to consider going down the checklist is life insurance, right? Now, a question often asked is, do I really need life insurance? And as I've been stating all along, there is no one size fits all answer, right? one big expense is, your final expenses, your funeral expenses. Like when you pass, your loved ones are going to have to deal with those expenses, and they include, and according to some, I'm in Maryland, so this DMV area, according to some local funeral home directors that I've spoken to, the average cost of a funeral can be more than $15,000, right? And then you add on to that, if there's a vault for burial, that adds even more. And I mean, if you're, talking about all the other accoutrements, that can be associated with a funeral, like doves and, police escorts and all the things, right? Plus, 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 right? And there are also some debts, right? If you have some debts, your estate, it's your estate's responsibility to pay off those debts, like when you die, and that's part of the probate process. Now, as a result, those debts may reduce the assets that remain available to your heirs or for your heirs. And then the last thing, but not the only thing, these are just examples, are final income taxes. The government is going to require payment of any back taxes you owe, plus any taxes owed in the year of your death. And during the probate process, your personal representative, or alone or working with the assistance of a tax professional, will prepare a final tax return, right? That's not submitted to the court, but it is important to be able to tidy up and close the estate properly, just to make sure that nothing is kind of hanging out there and owed, and your heirs can receive what you intend for them without fear of the government coming back saying, hey, you owe us X amount in back taxes. You don't want that. So life insurance, going back to the topic of this section, can help you cover those costs, as well as provide a source of funds for beneficiaries to meet those obligations, without having to tap into that estate bucket, right, of resources. And it can be, especially life insurance can be useful, especially if the estate has real estate or other assets that you can't easily liquidate, or convert to cash. Now, if you choose, I would be remiss if I didn't mention this, if you choose to self-fund, meaning that you have enough in savings to cover all of these costs and have plenty of left over for your beneficiaries without the need of a life insurance policy. Should you still get one? That is a question for you to discuss with, say, someone like a certified financial planner and or a tax professional, right? But definitely something worth mentioning, because, as I always say, estate planning really it's a team effort. You're going to have people like your CFPs, other financial planners, tax advisors, and of course, estate planning attorneys involved, providing you with valuable input for you to make educated, informed decisions about your particular estate plan. So, now the the final topic in this part of our review of the estate planning checklist is funeral expenses and final arrangements. Now this ties, of course, with the previous point I discussed. It's important to consider how your final expenses will be paid, and what kind of service or memorial you want. This part is more about allowing your loved ones a chance to say goodbye and to honor you. There are some people who are like, listen, I'm not even going to be here, so I don't care. They don't have to have anything. Well, just step outside yourself for just a second and remember that there are people that love you, people that certainly want to honor you in some fashion, whether it's a burial or a memorial service before you're cremated, whatever shape that takes. There are people that need and would appreciate a time to grieve and to honor you appropriately. So just keep that in mind, that a funeral service is more than just about you, even though you are the focal point of the ceremony. So what should you consider, right? Paying in advance, prepaid funeral plans. If you want to pay for your arrangements ahead of time, make sure that you are dealing with a reputable funeral establishment and clearly document any plans that you make so that your survivors can easily carry them out. Um, though the law requires, that those who provide funeral services to carefully manage those funds, abuses do happen. There are some unscrupulous people out there. What's more, if the funeral establishment goes out of business, all those plans that you created could be lost. So leaving a written plan for your funeral arrangements, including how to pay for it, is really a gift to the people that you leave behind. Your survivors or your personal representative, if you named one, have to follow that plan that you leave, and they will certainly be grateful for your forethought in the difficult days after your death. Now, it's best to leave your wishes in a document separate from your will. In the plans that we create, that document is often known as a final disposition and authorization. You can leave instructions about whether you want burial or cremation, and a memorial service if you want that too. Flowers, music, all of that. If you belong to a sorority or a fraternity and there's a particular ritual that is unique to those organizations, you can specify in this document that you want to have those rituals observed. They let key people in your life know what it is that you want without ambiguity. So, as you can see, there are a number of things to consider as you are getting your estate plan together. But this doesn't have to be overwhelming. And here's where we can help. If you're in Maryland and or the District of Columbia and you want guidance in creating your estate plan, give us a call. You've seen our website and contact information scrolling throughout these last 33 minutes or so. Give us a call. That's what we're here for. And you can also visit our website and download free materials to help you get organized. The message that I want you to take away from this is that, you don't have to do this alone, and we're here to help. But we believe strongly in educating and empowering our loyal viewers and our clients. So this is all a part of it. So take advantage of this. I want to thank you again for tuning into this episode of Women Winning Wednesdays. Be sure to tune in next week for another great episode. And, reach out to us. Did you like this episode? Did you find it helpful? And tell us what you want to see in future episodes. So this is Elsa W. Smith, your Maryland and DC estate planning attorney, wishing you well and a great rest of your week. I'll see you in my next video. Take care.